Jamie, unmute.
Jamie, you're on mute.
Sorry about that. I guess I was on mute, everybody. I'll start over. Hello, my name is Jamie Boston. I'm the chair of the Veterans Affairs and Military Law section of the National Bar Association. I just want to thank you all for taking time out to be here with us today. I think you'll find this program very informative, and hopefully you take the time to ask questions of this outstanding panel. I want to be very clear that this panel is not about police bashing. Most of us, if not all of us on this panel, have served as prosecutors or in some form of law enforcement. We're here to address issues that are apparent just by looking at the TV, that there is a systemic problem in terms of law enforcement in certain communities and certain classes. And so that's what we want to discuss about today. We have an outstanding group, and you'll be loving everything that you hear from them. But we have two young men that are going to kind of lead this program tonight, and I'm going to take a quick second to introduce them. But also, before we do that, I want to let you know that our esteemed president, President C.K. Hoffler, will be joining the conversation or saying a few words to you at some point during the program. But as you all probably know, she's very busy, so she's double booked a little bit, but she'll be popping in. So I don't want you to be surprised at some point we might cut the program for a second and turn it over to her to say a few words to you all. But with that said, let me introduce the two fine young men I talked about. I'm gonna do a short bio because we believe in getting to the meat of things instead of just wasting our time about introductions. If you want to know more about them, give them a call, give them an email, whatever. You can find out the whole bios. But first and foremost, we have Jeremy Broussard, who's going to be your primary host for the evening. Major Jeremy Broussard is currently an associate professor of criminal law at the Judge Advocate General's Legal Center School. He teaches evidence, Sixth Amendment, confrontation, trial advocacy, and a bunch of other things. He was commissioned and as a field artillery officer before he became a JAG officer, and has remained as a JAG officer for the last several years. He's had assignments all across the world. He has been deployed. He earned his LLM with honors, by the way, from the University of California, Los Angeles, UCLA School of Law. He has an LLM in military law with concentration in criminal law from the JAG School. And he is a graduate from Howard University School of Law and from Hampton University, where he was a graduate, proud graduate. So strong HBCU background, very capable leader. He's going to take you through the program tonight. And then the other part of the program would be Mr. Augustus Miller, Turner, rather. Major Turner is a soldier, lawyer, scholar. He's kind of a Renaissance man in our section. He's a writer, a scholar. He founded the blog Venerable Voice of Change. He's a second generation paratrooper, proud 82nd soldier. He received his bachelor's of arts in history from Wabash College and JD and a master's in biomedical ethics from Indiana University. And he earned a master's of laws in government contracting from the JAG School as well. Currently, he serves as attorney advisor of overseas contracting for the U.S. Army Contract Command in Huntsville, Alabama. With that, gentlemen, take it over. And again, thank you for attending tonight.
Thank you so much, Jamie. Thank you very much, ladies and gentlemen, for being here. This is great. And who you just heard from was Jamie Boston. He is the chair of the Veterans Affairs and Military Law section of the National Bar Association. I want to thank him, and I also want to thank Ms. Tricia C.K. Hoffler, the president of the National Bar Association, for organizing this event tonight. And maybe we may hear from President Hoffler later tonight for tonight's discussion about the brutality of the badge, understanding the challenges behind suing and prosecuting police officers for civil rights violations. Now, a lot of people in attendance may not know as much about the National Bar Association. So before we get started, I do want to say that the National Bar Association was founded in 1925 and is the nation's oldest and largest national network of predominantly African-American attorneys and judges. It represents the interests of approximately 66,000 lawyers, judges, law professors, and law students. The NBA is organized around 23 substantive law sections, 10 divisions, 12 regions, and over 80 affiliate chapters throughout the United States and around the world. So for more information about the National Bar Association, please visit the NBA's website at nationalbar.org. And also, this is the Veterans and Military Affairs section, and I am an active duty JAG, and so is Major Turner. However, this webinar represents the personal opinions of us and does not necessarily represent the positions of the United States Army, the Department of Defense, or the federal government. This brief should not be commented on or reproduced or quoted without our permission or the permission of the members of the National Bar Association, Veteran Affairs, and Military Law section. Additionally, this event is purely informational in nature and should not be considered as legal advice. So you got a panel full of lawyers. If you want a lawyer for yourself, I'm sure some of them will be available afterward for hire. But for these purposes, this is just for information. Now, why are we here? Let's talk about something that is only from a few days ago that I think kind of encapsulates a lot of what we're experiencing, what we're talking about.
Get in the car. An emotional confrontation. Rochester police responding to a report of family trouble.
She got multicolored pants and a black hoodie. And mom's saying she's making suicidal statements.
Officers trying to convince a 9-year-old girl to get into a police car. An officer eventually gives the girl, already handcuffed, a warning before using pepper spray.
Sit back. Come on. This is your last chance, otherwise pepper spray's going in your eyeballs. Come on.
I got her. Tonight, the girl's mother saying she will sue the city of Rochester and its police department.
I trusted the Rochester Police Department to do what they needed to do to help my daughter, not to abuse her or hurt her at all.
Here, just stop for a second.
I want my dad!
The police union says the girl resisted and kicked one of the officers and that they did not harm her when she would not comply. Authorities have said the girl had threatened to take her own life and harm her mother.
No one who would treat a 9-year-old child like that should be in law enforcement to help anyone.
City officials already have said the officers' actions were not appropriate. At least 3 have been disciplined. Now a lawsuit by a family claiming police used excessive force against their little girl. Ron Allen, NBC News.
What?
Now we see it time and time again, right? We see stories in the news about police beating someone, abusing someone, escalating rather than de-escalating. And unfortunately, too often we see incidents of people, particularly people of color, being killed by the police. And the question you ask, I know I ask, we all ask is, what can we do about this? Why aren't those police arrested? If you or I had shot and killed someone, we would be in jail awaiting trial for murder or manslaughter. Why aren't they suing the police? Why can't that be a remedy? The purpose of this presentation in large part is to help explain the complexity of this, the challenges of this issue, and hopefully at the end of this to help you have a better understanding of the difficulties and challenges regarding both prosecuting police for misconduct, particularly when they violate people's civil rights, and also even the civil remedy of suing them for violations. Now, you may be asking yourself, okay, Jeremy, you're part of the Veterans and Military Affairs section. Why are you guys talking about this? Well, we as veterans and we as service members took an oath to preserve and protect and defend rather the Constitution. This is the Constitution we're protecting and defending. We want to discuss these issues about how to make this a more perfect union, and for us in uniform and those who serve, how to continue to make this a place worth fighting for. And with that, I'm going to turn over to my colleague, Augustus Turner, to talk to us more about these issues and how we can empower ourselves.
Thank you, Jeremy. Good evening, everyone. My name is Augustus Turner. As Jamie stated before, I'm a judge advocate and a former special assistant U.S. attorney. However, tonight I'm here in my personal capacity to speak with you about I'm here to speak with you about the essential steps as a case transitions from an investigation to a prosecution, and also discuss the difficulties in bringing lawsuits against public officials such as police officers. Now, if you're not a lawyer, that's okay. This is perfect. This is perfect for you. If you're a criminal lawyer, or if you're not a criminal lawyer, if you're a lawyer but don't practice criminal law, that's okay. That's perfect. I'm going to help explain that to you, and I'm going to help explain the basics of some fundamental things you might see on the news about these cases, common terms you might see, such as indictments, arraignments, probable cause, qualified immunity. Now, if you have questions during this time, go ahead and put them in our chat, and our panel will answer them Let me go ahead and bring up the presentation for you. All right. So what I'm going to talk to you about is empowering you by learning about the process, essentially. Now, our conversation is going to be centered around four main questions that I commonly receive. One, who investigates police misconduct? Two, who decides when the investigation actually ends? Three, what is the general process to bring charges? And four, why is it so hard to bring a personal lawsuit against a police officer?
Mr. Turner, excuse me one moment. We're getting some feedback from your microphone and the attendees may not be able to hear.
Okay.
We need to turn down one of your devices. Thank you, sir.
Okay.
Okay, let's test your audio again.
Feedback better? You hear me?
That's a little better.
All right. Better now?
Yes, thank you.
Okay. Sorry about that. So the first question that I normally get asked is, who investigates police misconduct? We often see situations where sometimes the FBI may step in. Sometimes we see situations where a state attorney general may step in, and sometimes we see situations where neither step in and intervene in police misconduct. So some people may say, well, why is the FBI getting involved here in this case and not the other? So to clear that up, the federal government, the FBI, the U.S. Attorney's Office, they only get involved when there's a potential violation of federal law. The State Attorney General's Office, they normally only get involved in cases when it's required by state law. Some states require the State Attorney General to investigate police misconduct anytime it happens. And in other situations, they're asked to get involved by the governor or by the mayor or by the local police department, usually because there is a conflict of interest. Otherwise, normally the officer's own department will take over the investigation. So the next question I usually get asked is, when does the investigation end? And contrary to popular opinion, it's actually a decision that's not up to law enforcement. The decision of when an investigation ends is actually up to the prosecutor. Police cannot unilaterally end an investigation, a criminal investigation. They have to go to a prosecutor and seek that prosecutor's opinion as to whether they believe there is enough evidence to go to the next step, to move from an investigation to a prosecution. And you might be asking yourself, what is that threshold? How do you get a case from the investigation to the prosecution step? And for us, it's the question of probable cause. You might have heard that term used a lot. Probable cause simply means reasonable suspicion. That is a very low threshold. That's a lower threshold. That's less than 50%. It's not proof beyond a reasonable doubt. It's not a preponderance of the evidence. It's essentially that. It's reasonable suspicion. I am suspicious, and my suspicions are reasonable. It's a very low standard to go forward and consider a prosecution. If a prosecutor believes there's enough evidence to get over that threshold, then the investigation can end and you can pursue charges. So the area I'm going to spend most of my time talking to you about are what goes into the decision to prosecute. In other words, I'm going to pull back the curtain and sort of explain to you the major three steps that prosecutors, whether you're in a state level or the federal level, that goes into the prosecutor has to go through to bring charges. And so those three major steps that we're going to talk about tonight is, and probably the most important question is, that the prosecutor has to ask is, was the officer's conduct objectively reasonable? The second thing is preparing a charging document. And the third thing is presenting that charging document to a grand jury or a judge. So the first step, was the officer's conduct objectively reasonable? Now you might be asking yourself, well, why is that important? Well, the reason why it's important is because if an officer's conduct was objectively reasonable, and this is law that comes to us from the Supreme Court, if an officer's conduct is objectively reasonable, it is not criminal, and that might deter a prosecutor from even bringing charges against an officer, or sometimes it might stop a case in its tracks before it gets to trial. So you might be asking yourself, well, how do I know if a case is objectively reasonable? Ask yourself this question: would an average police officer with standard training, no emotions, put that average standard officer in the same situation as one in a scenario where there's an officer accused of misconduct? Would that average officer perform the exact same? Would they do the exact same conduct? And if they would, then more likely than not, you do have a situation where it might be objectively reasonable. So again, this is very important because some prosecutors might believe or suspect that an officer's conduct, even though it is questionable, might be objectively reasonable, and that might deter them from wanting to bring charges. So you might be asking yourself, so how do I know if something is objectively reasonable or not? You know, what stops all police officers from all their conduct being deemed objectively reasonable? So the Supreme Court also gives us 3 factors in this, helping to decide whether we have a conduct that is objectively reasonable. The first thing is the seriousness of the crime. The second thing is whether the suspect is actively resisting or attempting to flee. And the third is whether the suspect poses an immediate safety threat to himself or others. And as you look at these 3 factors, this helps to distinguish between the situation where a police officer might, during a traffic stop for a broken taillight, walk up to the driver and shoot them, versus a hostage situation where lives are at risk. A police officer who shoots someone for a broken taillight, that's not objectively reasonable based on these 3 factors. And these factors help us to measure what is objectively reasonable and what is not, regardless of the excuse. The second thing is to prepare a charging document. Now, what is a charging document? I have an example of one here on the slide to your right. There are 2 types. The content in them is exactly the same. They could be called a criminal complaint. You might have heard that term used in the media before, or more commonly, you might have heard of something called an indictment. That's just the name of the document. The contents are the same, and I'll get into the difference here in a bit. But the document explains what crimes were committed, who committed them, called the defendants, and how the crime was committed. And in the example, you can see on the top left-hand side, you can see the listed defendants, the suspects of the crime. On the right, you can see the list. There's about 3 charged offenses, 3 crimes that are involved in this case. And you see the introduction to the story. And this document is prepared by the prosecutor. The prosecutor looks at the evidence and they say, well, what charges can I bring? And what can I prove? So the document is opinion-free. You should not see opinion in the document. It's entirely based on things that the prosecutor can prove with evidence. So the third thing is presenting this document. And actually, so how do I go from presenting a charging document? You might see an indictment on TV when someone's charged. How do I actually charge someone with a felony, or a police officer with a felony? There are 2 ways. You can take your charging document to a judge. In that case, it's called a criminal complaint. And this is the same process that a prosecutor would go through to get a search warrant. They would prepare 3 documents: the criminal complaint, any evidence that supports it, and a document called an arrest warrant. And they would meet with the judge in private, just one-on-one. There's no defense counsel there. They would meet in the judge's chambers, usually the judge's office, and the judge would review all of these documents. If the judge is convinced that there's probable cause, then they would sign the criminal complaint and they would sign the arrest warrant. At that point, the defendants are charged with the crimes, and with the arrest warrant being signed as well, police can go arrest the defendants. Again, this is the same process that a prosecutor would go through to obtain a search warrant. They would bring the documents to a judge and then try to obtain probable cause. Now, the part that you're probably more interested in, though, is a grand jury. And a lot of people, there's been a lot of talk in recent cases over the last year about grand juries and how they work. I've worked with grand juries before, I've brought cases before, so I wanted to help explain exactly what grand juries are. Again, if you have questions, go ahead and put them in the chat. Again, our esteemed panelists have worked very closely with grand juries as well, so they'll be able to answer them if you have questions from what I'm talking about. Let's say you want to bring a charge to a grand jury. The same process as I just described. You prepare your charging document, in this case, same document, but it's called an indictment. You bring your evidence, and you bring it into a room such as this one that I've got pictured here to the right. This is a grand jury room. Every courthouse, every state and federal courthouse has one. It's where the grand jurors meet, and they meet in secret. There's the only person allowed in the room with a grand jury as they discuss a case is the prosecutor. The prosecutor oversees the grand jury. There's no judge allowed in the grand jury room. There's no one else's lawyers allowed in the grand jury room. The public is not allowed in the grand jury room. If the grand jurors have questions, if they need advice, they go to the prosecutor who's in the room. So as you can see, the prosecutor has a lot of influence over the grand jury and how the grand jury proceedings operate. Now, the grand jury proceedings are recorded, but they're not released to the public unless a judge authorizes it generally. So let's say you're a prosecutor, you bring your documents, you want to bring charges, you want to bring an indictment, and you want the grand jurors to vote on it and charge these individuals. Let's say the grand jurors have questions, or let's say they want to see more evidence before they make a decision. They can bring more evidence to inspect, whether it's a witness or documents. They can issue a written demand called a subpoena, and the only way you can deny a subpoena or refuse to comply with the subpoena is if a judge says you can. So it's very powerful. Now, once the grand jurors, once they've decided that they've seen enough, and if they believe there's probable cause that you've committed the crimes in the indictment, they'll vote, just like a jury in a trial. And if there's enough votes, then those people are charged or indicted. So you probably heard that word used a lot too, and that's what that means. That's when a grand jury has voted to charge you with a felony. And at that point, same as before, you are charged with those crimes. Now, the last step I want to talk to you about is arraignment. Let's say you're charged, whether through a criminal complaint and a judge or through the grand jury and an indictment, and you've been arrested or you've turned yourself in. The next step is an arraignment. Now, I like to call this the Law and Order 30-minute mark moment. So for all my friends or everyone out there who watches Law and Order, everyone knows what happens at 30 minutes. The suspect is arrested, and the next scene is they're hauled into court, and they're arguing about bail. They're arguing about, you're hearing the judge, go back and forth. An arraignment, regardless of where you're at, is always the first time the defendant appears in court. So that's what you're seeing. That's why I call it the 30-minute mark in Law and Order, because you're always seeing the arraignment at that time. Now, there are 4 things that always happen in an arraignment. The prosecutor will announce the charges. The judge will make sure the defendant knows their rights and that they have a lawyer, or that they have an opportunity to get one, and the defendant will enter a plea. Again, for those who watch a lot of TV or movies, you've probably seen this happen before. That's what an arraignment is. You probably hear that a lot in media, and that's what that is. And finally, about going back to grand juries for a second, some people may ask, well, why go to a grand jury at all? Why can't when I can just go to one person, a judge? Well, there are certain things that happen at the arraignment. There are additional things that complicated things that have to happen at an arraignment if you choose to just go to a judge and not go to a grand jury. Also, if you skip the process entirely and just arrest the person without doing either of these steps, the arraignment becomes much more difficult for the government. And so let's stepping aside finally from criminal prosecution, stepping aside from criminal charges and all of that. Let's just say you want to sue the police officer. Let's say you were arrested one night by a police officer. You were handcuffed, and the police officer sicked his dog on you while you were handcuffed and laying on the ground, and you want to sue the police officer for $1 million. Why is it so hard to sue the police officer, you might be asking? And the reason is because of qualified immunity. Qualified immunity, to try to make it as simple as possible, it means that I have to find an identical case, meaning a situation where I was another case before mine where a court said that, hey, when an officer sicks his dog on a man who's handcuffed and laying on his belly, that's unconstitutional. I need to find another case where that exact fact pattern happened and the court said that violated my constitutional rights. And if I can't find it, my case will more than likely be dismissed if I sue the officer. Now, this doesn't apply to government entities, which is why a lot of lawsuits, like the one you saw in Jeremy's introduction, the lawsuit doesn't go against the officer, it goes against the city or the police department. So in conclusion, we had 4 questions, we have 4 answers now. Outside agencies will step in certain circumstances to investigate misconduct. Prosecutors will decide when the investigation ends, not law enforcement. Hopefully you now have some introduction to grand juries and how powerful they are, the secretive nature of them, and how this process in grand juries are very controlled and steered by the prosecutor. And finally, that you can't sue a police officer unless you find a situation in a previous case that mirrors yours, and that's very difficult to do. So with that, I really breezed over these topics, but I wanted to help to empower you by helping you to learn about the process. Knowing about the process, again, I'm not here to attack or defend the system, but in my time of helping sex assault victims, the most powerful thing I can do is help them know what happens next in the case. And so I want to help empower you as well by helping you to know what happens in these cases. But if you have questions about them, now we're going to get to our panel, and I'm going to give it back to Jeremy so that he can introduce our panelists here.
Hey, Augustus, thank you so much. That's great. And again, Augustus knows what he's talking about. This is a guy who doesn't just kind of brief you guys on slides. He was a special assistant U.S. attorney, which means he was a federal prosecutor out in the Western District of Kentucky, which is in Bowling Green, about 2 hours east of Lexington. Before we introduce the panel, however, we're very privileged tonight to have President Tricia C.K. Hoffler, our NBA president, here at this event. So I do want to turn it over to you, Madam President, for some remarks to the group and to the audience. Thank you again for coming.
Well, first of all, thank you so much for inviting me. It is with a great deal of humility and honor that I bring greetings tonight with such an incredible panel. I see my Vice President, Lonita Baker. I just have to talk about Lonita Baker for a moment because we don't always see women at the forefront of this type of litigation, representing families of those who have been victims of police brutality. But when we do, and if we do, we certainly want them to be like Lonita Baker. So I salute you, Lonita. I see Terry Wiley. So now we have California in the house. I just want to say thank you, Terry, for all that you do, the extraordinary promotions that you have received representing the NBA so well. And I just wanted to thank you for all that you do and always making us look good. Jamie Boston. So the Veteran Affairs and Military Law section of the National Bar has a particularly strong place in my heart because my father was in the military. My stepfather was in the military. 2 uncles were in the military. And several cousins were also in the military, both men and women. And indeed, I think the greatest service that we can pay to this country is serving in the military. And so when Jamie Boston first approached me, who we know is extraordinary, and we thank you, Jamie, for what you do, not only in your service, but in what service to this country, but in what you do for the National Bar Association. I was just delighted because I wanted to publicly say in some way, shape, or form, thank you to those men and women who stand on the front lines every single day in protecting this country and our way of life. Because when we talk about police brutality, when we talk about the ability to sue and prosecute for civil rights violations. It is those brave men and women who are on the front lines who fight for our ability to do that. So I want to thank you. To Augustus Turner, I heard your remarks. Thank you so much for situating some of the issues and giving distinctions to many of us who, some of us do this kind of work, but for those who don't, they have a lot of questions. And to Jeremy Broussard, who is pulling all this together, and I believe you set the table. And I came in late because I have 3 webinars where I have to bring greetings at the same time. Yes, 3. And so, and we all know that I'm a speaker. I talk and I speak. I'm originally from upstate New York. I speak quickly, but I went from one to the other to the other. From Flint, Michigan was the first one, and to a YLD event, ABA YLD event, and to this. And I don't want to say I saved the best for last because I just don't want to say that, but I'm going to be here the longest. And hear Joanna Schwartz and all of you comment on this incredible issue, which is frankly a reflection of one of the buckets, the areas that I focused on in my administration this year. So thank you all. I'm going to be quiet. I want to learn. I have done some of these cases. When I think of excessive use of force, I think of the first case that I remember doing in the, I want to say 90s or early 2000s, where there was a 5-year-old child in Pinellas County, Florida, who was acting out. Her name was Jaisha Scott. You all may remember this case. She was acting out in a classroom. She was 5. And the school officials thought that she was a threat to someone, and they called the police on this 5-year-old girl, and they handcuffed her. And then they took her and put her in the back of a police car and put shackles on her feet. And she sat there for 3.5 hours without having access to her mother. And they tried to Baker Act her, and this was in Florida. They tried to Baker Act her, which was mean they tried to institutionalize her. And she was having a meltdown. I have 2 children. My goodness. If we had to, when they were that age, talk about the meltdowns that they had, I just sort of would do like this and give them that look. But my point is the injustice against children. And I've also done adult cases. For me, that's how I started. So against that backdrop, thank you so much. Jamie, thank you for including me, for inviting me. Lanita, you just keep on keeping on. Terry, do what you do. Augustus, you too. Jeremy, you as well. And Joanna, thank you in advance for all your contributions.
Thank you so much, President Hoffler. And she didn't say it, but we know that she saved the best for last. So again, thank you very much for that. Fantastic panel. I do want to have the honor now of introducing them. As we just said, Ms. Lonita Baker, she's a personal injury attorney, litigation attorney at the Sam Aguiar Injury Lawyers in Louisville, Kentucky. Prior to joining that firm, she served as a prosecutor at the Jefferson County Attorney's Office in Louisville for more than 6 years. While at the Jefferson County Attorney's Office, she practiced in the Legislative Services branch of the Civil Division and as a supervising prosecutor in the Criminal Division. Attorney Baker began her legal career at the Louisville Metro Public Defenders Corporation, where she represented individuals charged with misdemeanors and felony criminal offenses. So she has done what we say both sides of the V, both sides, prosecution and defense. Attorney Baker graduated from the University of Louisville with a Bachelor of Arts degree in psychology and minors in sociology and Pan-African studies. She continued her studies at the University of Louisville at the Louis D. Brandeis School of Law and obtained her Juris Doctor. She later obtained a Master of Business Administration with distinction from the University of Louisville College of Business. Attorney Baker bridged her undergraduate degrees and law degree to become a strong negotiator and litigator for her clients. And again, litigation, negotiation, litigation are hand in hand. In addition to personal injury, Attorney Baker practices civil rights cases to help make citizens whole after negligent treatment by law enforcement. A little timely. In 2020, Attorney Baker gained national attention in her representation of the family of Breonna Taylor. This case was one of the pivotal points in her career, resulting in a groundbreaking settlement with the city of Louisville, which included terms of police reform, in addition to one of the largest financial awards for an individual civil rights case to date. Breonna Taylor's case sparked legislation at the local and national level. Very true. Attorney Baker has received several awards for her service to the legal profession, including being named a top 40 under 40 attorney by the National Bar Association and the National Black Trial Lawyers, receiving three presidential awards from the National Bar Association and was named the 2019 Justice Award recipient for the Louisville Urban League. In 2020, Attorney Baker earned recognition as a top 40 under 40 by Louisville Business First, a Wiley Branton awardee by the National Bar Association, and the Daniel M. Alvarez Champion for Justice Award by the Louisville Bar Association. Attorney Baker is also a proud member of the Alpha Kappa Alpha Sorority Incorporated. It's enough said about that. That's impressive. Again, thank you so much, Ms. Baker. Professor Joanna Schwartz is also here from the University of California, Los Angeles. Go Bruins. She's a professor of law and teaches civil procedure and a variety of courses on police accountability and public interest lawyering. She received UCLA's Distinguished Teaching Award in 2015 and served as Vice Dean for Faculty Development from 2017 to 2019. Professor Schwartz is one of the country's leading experts on police misconduct litigation. She's additionally studied the dynamics of modern civil litigation. She co-authored the leading casebook, Civil Procedure, 10th edition, and her recent scholarship includes articles empirically examining the justification for qualified immunity doctrine, the financial impact of settlements and judgments on federal, state, and local law enforcement officers and agency budgets, and regional variations in civil rights protections across the country. I looked her up. There's over 12 articles. I stopped counting after 12. This includes New York Times op-eds and law review articles. It's amazing. She even teaches a course called Suing the Police. Doesn't get any clearer than that, folks. Professor Schwartz is a graduate of Brown University and Yale Law School. At the law school, she clerked for the Southern District of New York and in the Ninth Circuit Court of Appeals in California. She was then an associate at a law firm in New York City, where she specialized in police misconduct, prisoners' rights, and First Amendment litigation. Thank you so much, Professor Schwartz, for joining us. And finally, we have Mr. Terry Wiley. He is the Assistant 2 District Attorney and the number 3 ranking prosecutor in the Alameda County District Attorney's Office in Oakland, California. Mr. Wiley is an advocate for criminal justice reform and fighting inequities in the adult and juvenile justice system. He has vast criminal law experience, having served in most assignments in the District Attorney's Office. He is a highly skilled trial attorney and has prosecuted very difficult and challenging criminal cases. He has a reputation for standing steadfast for justice regardless of the person committing the crime, and is shown in the case of 3 Oakland police officers who call themselves the Riders. We're going to have to talk more about the Riders. It's like a movie waiting to happen. Mr. Wiley sought justice for the individuals who fell prey to these 3 rogue police officers. Now, he is supervised at all levels of the District Attorney's Office, including the felony trial teams, the juvenile division, the Oakland branch courthouse, and appointed the Director of Recruitment and Development. Now, just a few months ago, November 2020, Mr. Wiley was promoted to Assistant 2 District Attorney and appointed Director of the new groundbreaking Division of Diversity, Equity, and Inclusion. He has been a big part of efforts that have led to the creation of several programs and collaborative courts that offer alternatives to incarceration, providing individuals charged with crimes the opportunity to gain insight, build skills, and complete their education and to move on beyond the criminal justice system. This is important. As the state of California reports, the Alameda County DA's office has more collaborative courts per capita than any other in California. It's amazing. Mr. Wiley has distinguished himself in a greater legal community. He is currently a member of the American Bar Association's Criminal Standards Committee and a past member of the State Bar of California's Board of Trustees. Also, past vice president of the National Bar Association. He has served on the board of the California District Attorneys Association and worked with the National District Attorneys Association. He speaks in many community events addressing reform in our criminal justice system. He's a native of California and a graduate of UC Berkeley. He also played football and ran track there in track and field. And finally, he's a graduate of the University of San Diego School of Law. So thank you, panelists, again. So just everyone watching and listening, we have just the best of the best here tonight or this afternoon if you're in the West Coast to discuss these issues. And what I want to start out with is I know a lot of Augustus's presentation talked about the process of prosecuting. And I think it's fair to say most of these cases aren't even envisioned for criminal prosecution, but a lot of people may look at civil remedies, lawsuits. just doing some research before we came on, it was staggering. Now, individual police officers, they have qualified immunity from lawsuit and civil suits. However, the municipalities pay the price. The cities pay the price. You and me, we pay the price, right, with our tax dollars. Now, listen to this, folks. In the first 2 months of 2018, the city of Chicago paid out over $20 million for police misconduct. 20 million taxpayer dollars being paid to people because of what their police did in their official duties. New York City paid $302 million in 2017 alone, and the following year paid another $230 million. So New York paid over $500 million in just 2 years, one city. This is according to a 2020 story from Marketplace. So I'm going to start with Professor Schwartz. With so many city governments, and probably states as well, paying out tens and hundreds of millions of dollars in taxpayer money, what is the continued rationale for denying individual liability of police officers when they commit civil rights violations?
Well, thank you. First, I should say thank you for having me, and thank you for including me in this conversation. I'm really honored to be part of it. You have really put your finger on a key fallacy in qualified immunity doctrine. So qualified immunity is intended, if you look at the Supreme Court's opinions, the Supreme Court describes it as necessary to shield officers from financial liability in these cases. And what the Supreme Court says is that if officers didn't have this qualified immunity, they would be threatened with bankruptcy anytime they were out on the street doing their jobs. And that danger would make officers overly nervous while doing their jobs, not vigorously enforce the law, and that people wouldn't agree to become police officers at all. But as your records show, police officers very rarely contribute anything personally to settlements and judgments entered against them. I looked at payouts in police misconduct cases in 81 cities across the country over a 6-year period. And I found that cities paid 99.98% of the dollars awarded to plaintiffs in those cases. Among those 81 jurisdictions, there are only 2 that I found that had any case where an officer had paid anything. And the amounts that they had paid were the average was about $2,000. So this evidence goes strongly against the justifications that have been given by the Supreme Court and other defenders of qualified immunity for the doctrine. I should say, and I'm curious to hear what my co-panelists think about this, I actually think that it is the right thing for taxpayers to be paying settlements and judgments in these cases. We have given police officers badges and guns. We pay their salaries, and we need to reform and address problems. We need to find ways of disciplining and firing and creating consequences for officers who violate the law. But if the money were taken out of officers' individual pockets, most officers would not have the money to pay settlements and judgments in these cases, particularly the kinds of large judgments that happen in the most egregious cases. And so if individual officers were left responsible, the people whose rights have been violated would not get the relief that they are entitled to. So in my view, it makes sense that the money does come from us, the taxpayers. But that fact means that qualified immunity doctrine really has no justification, no policy justification along the lines that the court has offered.
Ms. Baker, I wanted to build on that with you. Again, you were part of the groundbreaking settlement with the city of Louisville regarding the death of your client, Breonna Taylor. What are your thoughts? I mean, it would probably be impossible to get that type of financial award and the accompanying policy changes if these police officers were individually, personally liable. Is there something to be said for having institutions, understanding that also means the taxpayers are on the hook, liable to maybe one, push people to pay out, to actually be able to pay families or people who are or have their civil rights violated, and two, to put public pressure to change the way we do business.
Yeah, and I do. So in Kentucky, it's a little bit different. So our city, we can't sue our cities because of sovereign immunity. So I don't want people to think that, we just go out, we sue the cities, but we do sue the officers in their individual and official capacities. So it's in that official capacity that the city gets caught paying the settlement. And that's the same for most employers in personal injury cases. So I agree with Professor Schwartz that yes, it is the employer that should be paying any settlement amounts, and I stand by that. I do want to go back though a little bit, and we have to continue to chip away at qualified immunity. I do think also that qualified immunity is probably one of the most misunderstood concepts out there. And so a lot of attorneys, especially those who practice personal injury for the plaintiff side, they shy away from civil rights cases because they always go, oh, it's qualified immunity. But there's ways around it. You look at what are the policies of the department. And so you can bring in the official capacity claims there. Taylor v. Rojas, it's just over the last month or so, but we've had so much more news going on that Supreme Court case ruling probably flew by most people, including those of us who practice in civil rights. So it chipped away just a little bit at qualified immunity, where it's not so stringent, where Major Turner talked about it before Taylor v. Rojas. Every case from the Supreme Court said that you had to find a case exactly on point in order to be able to be qualified immunity. But now with Taylor v. Rojas, the Supreme Court has said it does not have to be exactly on point. Then you do have to look at the facts of that case. It was significant, it was severely egregious. And so why they deferred from, okay, yeah, we don't have a case where we've had someone sitting in feces in a jail cell right on point, but you don't need that for corrections officers to know that this is a violation of someone's civil rights. So we always have to continue to look for, is this a widely known civil rights that the officer is violating? And if it is, you can get over that qualified immunity. But yes, cities are going to continue to pay it. I do think that we should begin to look at whether we require officers to carry liability insurance. Could that be a condition of employment so that they are somewhat responsible? They do have some teeth in the game. But Professor Schwartz is correct. If I wouldn't got a $12 million judgment against the officers who killed Breonna Taylor, we're never going to see any penny of that $12 million. So, and then the officers are just going to file bankruptcy and we never get anything. So the people are still, they're not going to be made whole. So the same as if you go to Walmart, you slip and fall in Walmart, you bring in someone on the store level who was negligent, but you also bring in Walmart as that bigger body. It's the way of personal injury litigation.
Understood. So I want to pivot a little bit with you, Terry Wiley, and talk about the other form of accountability, which is criminal investigation and prosecution. And by way of that, I want to give a quick little anecdote. This is my short stint as a civilian prosecutor. I was in DC. I was a special assistant U.S. attorney. So we worked with Metro PD, and there were these two detectives, right? And they weren't in court. And these guys, they stand around for like 7 or 8 hours and get paid to hang out. Better yet, if it's overtime for them. So they were no shows. I called them for some case. They were not there. Went back to my office around 2 or 3 in the afternoon. They showed up saying, hey, can you sign my time card? I was there for 6 hours. I was like, no, you weren't. I'm not signing your time card. And these detectives blew up at me. And what I remember, they also play good cop, bad cop. So it's not just a thing you see on TV. Good cops can play good cop and bad cop in real life. I'm here to tell you. But what I remember them saying was, looking at my name on my little desk and saying, oh, Broussard, huh? I hope there's no cases involving you. And I remember thinking, wow, these guys would really kill a case I've got. So I was doing misdemeanor cases, so if it was important, I wouldn't be doing it. But they really would kill a case I had because I wouldn't sign a time card and give them some money. Now, with that in mind, understanding these are just 2 detectives in 1 precinct in 1 city in 1 instance, you have prosecuted, and it's fair to say, I'm sure your office has investigated and prosecuted other police officers for misconduct. But these prosecutions require investigation, which is normally done by other police or other law enforcement. They require witnesses, typically other police, other law enforcement. And there may be, I'm just spitballing, maybe a little awkwardness in the office if I, as a prosecutor, rely on police to help me put together my cases, and I just help put one of them in prison. Could you tell the audience a little bit about the challenges of prosecuting police officers for misconduct, particularly civil rights violations?
Yes. Before I answer your question, Jeremy, I first want to acknowledge the president of the National Bar Association, C.K. Hoffler. I think her introduction gave everyone an indication what a classy president she is, and does a great job of representing the National Bar Association. And I also want to acknowledge all of our hosts in this program. And I can't start without saying that I've served on the board of the National Bar Association for several years with Juanita Baker. And, having done this for 30 years, the job she did representing Breonna Taylor's family in the civil litigation was outstanding in terms of the quality of the representation, the way she represented herself, the National Bar Association, to the nation. She did a great job. So I just want to acknowledge her on that. I do want to, before I answer your question, I do want to go back to the first question you asked Professor Schwartz and Ms. Baker in terms of qualified immunity. I just want to say that I do agree with Professor Schwartz in terms of it definitely is better to go against the government entities instead of the individual officers. However, I do want to say that in my 30 years of practicing as a prosecutor in Oakland, it has been some of the civil rights lawyers that have had the biggest impact in terms of change in police departments with successful litigation. And so I think that, although some attorneys run, like Juanita said, when they hear civil rights, but it is through civil rights litigation that you can foment some of the most change within the criminal justice system institutionally in police agencies. Now, specifically to answer your question, if I was a young prosecutor, then yes, I'd be concerned because the officers are angry at me, but I'm not. I'm a 30-year prosecutor, and I know that you can't get anything done as a police agency unless I say so. So, and I'll give you a prime example of what I'm talking about. We had a unit of the Oakland Police Department that decided on their own to go do what is called a reverse sting, in which they were making little rocks of cocaine using ivory soap. And they brought in about 40 cases of these reverse stings. And we didn't charge any of those cases because we said that our position is that we bring individuals into the criminal justice system that when we step in front of a jury, we're not stepping in front of a jury with ivory soap. And at the end of the day, we didn't catch them with any illegal contraband. And I'm not saying that it's right that they should be out there purchasing what is ivory soap, but allegedly rock cocaine. My point is that they didn't do any more of those reverse stings. And it's because the prosecution had the power to affect what sort of police operations they're out there doing. And I'll give you another example. Let's say in the scenario you gave me, those officers were angry with me. I'm like, fine, you're angry with me. And they bring me an a kind of half-done investigation. Well, all I'm gonna tell them is take that investigation back over to your department and give me a thoroughly investigated case. And if it's a case that they want to get charged, and that's what police officers do. They make arrests, they do investigations, and then they come over to the prosecutor's office to see if we will charge the case. So I've been around long enough to know that in most cases, the police agencies need me more than I need them. Okay. And in terms of them not wanting to do follow-up investigations, well, then all I do is go to a supervisor. So anyway, that's how you would normally handle that. And really it's understanding, if you've been around long enough, really in most cases, police agencies need the prosecutors more than the prosecutors need the police agencies, even though we work hand in hand in terms of trying to keep communities safe and prosecuting the appropriate cases.
Major Broussard, can I add on to what?
Absolutely, Ms. Baker.
So Terry and I, we do go back on the board. We worked together for a number of years, but I remember being excited when I met Terry because I think we were the only two prosecutors on the board at that time. So I've stated a number. Terry said that civil rights attorneys have the most impact and have pushed forth the most change as it relates to the way that policing is done. I think we have to go a step further and adding on and co-signing to what Terry said. We need our prosecutors to really step in and do what their role is, like their ethical obligation is to effectuate justice. And when we get more prosecutors that do exactly what Terry said, to push police officers to do their job correctly, to look for police misconduct in cases and know that, like, no, I'm not gonna prosecute this guy based off of this information because I know you went about getting it the wrong way. The more prosecutors that we have that realize the power that they have in this system, that they do not work for the police officers, but the police department is their investigative body, I think that we will go a long way and we will truly get much more reform, and police would do they will uphold our rights. They're not gonna, if they come and Terry asks, well, why'd you pull them over? And they give, a shoddy answer that did not provide probable cause. And he says, no, I'm throwing it out. After Terry throws out all of his cases, he becomes useless if he continues to do that, right? Correct. And so he has no choice but to change his behavior and do it right. So I think prosecutors, we need more prosecutors to step up and really take honor and do their oath, uphold their oath.
And can I say just one thing, just to back up what Lavinia just said, and I just want to give everybody an example. So in Oakland, we had a situation where officers were pulling over predominantly African-Americans on their bicycles for not having a light on the back of the bicycle. And so these cases were coming across my desk and I'm reading them, and the initial stop was because the person didn't have a light on the back of their bicycle. And so the officer that was bringing me the cases, I said, take these cases back over to your department. And when I see some white kids being brought in here for not having a light on the back of their bike, then we can talk about these cases. And they stopped bringing me those cases. So my point is that we can have, prosecutors can have a lot to say and dictate how police officers do their work, because a sergeant will go, hey, stop arresting people for bicycles because the DA won't charge them. So anyway, sorry, I didn't mean that.
I appreciate that. I want to build on this discussion about the police, because again, it's a cultural issue. I would assume it's a cultural aspect to this. And I think the culture of this is probably best personified by police unions. And if you think about unions, you generally think about collective bargaining, pay and benefits, workplace conditions. Police unions are kind of unto themselves in terms of the lobbying, in terms of the public messaging that they have about what happens. And typically, when you hear police unions, they tend to be speaking more in a defense of police who are accused of misconduct. Maybe it's a bad shooting, maybe it's a civil rights abuse of someone like that. The story we played at the beginning of this presentation, even though the city acknowledged it was wrong for that young 9-year-old to be pepper sprayed and handcuffed, the police union had already said that they were staying by their officers. So it seems to be sort of, they're backing you up, right or wrong. I'd like to start with you, Professor Schwartz. What is the role police officers play? I understand we've kind of established it's probably best that there is a degree of civil liability for municipalities because they can actually pay judgments, be it settlements or court order. But what is the role that these police unions play, maybe in terms of the public perception about police misconduct? In other words, could it really be that bad what police are doing if their own union is standing in lockstep with them?
So, I mean, I think unions have played a really powerful role in challenging, in many instances, police accountability efforts, particularly. I mean, it's been true for decades, but certainly in these past months, as police reform has been such a focus. Unions have played a variety of different roles that, for the most part, have been pushing against reform efforts. One way in which this happens is that union agreements often limit the people's access to complaints that have been brought against officers, so that a person bringing a civil rights case, for example, can be harder to access that information. There can be other kinds of protections put in that, for example, let officers have 24 or 48 hours before they speak to an investigator after they've been involved in a shooting. And those kinds of protections can also make it very difficult to begin the steps towards criminal prosecution or civil liability. I can also say that I have been in several conversations with unions recently, because there are state legislatures around the country that are thinking about what they can do. And one thing that they are doing is introducing bills that would allow people to sue under state law for constitutional violation without the protections of qualified immunity. So some pressures have been for the Supreme Court to change the doctrine, or Congress to get rid of the doctrine, but state legislatures are making these pushes as well. And in the testimony, the hearings that I've been involved in, the strongest opponents have been union reps who have talked about the same, what I consider to be myths about qualified immunity, that without it, officers will be bankrupted for good faith mistakes. But it is union leaders who have been being spokespeople for that view in the state hearings and in pressuring Congress as well. So there's what role unions play is a big question. I hope I've taken a little piece of it, and hopefully my co-panelists can take some more.
Mr. Weil, I want to get your thoughts because you're still working with police day in, day out now.
So I'll give you my opinion of unions in general. I mean, I think the role of a union is to go and negotiate the best contract that they can negotiate for the members. And it doesn't matter whether you're a union for janitors, plumbers, police officers, or firemen. They're going to go in and try and negotiate the best contract that they can get from whoever they're negotiating with. Okay, that is not really the problem. What you find is that in most cities, and I will tell you that in the city of Oakland, I don't know who in the heck they have representing the city negotiating those contracts and some of the terms that the unions are able to extract. But I think that many of the cities have, quite frankly, done a very poor job of negotiating the terms of union contracts. And one of the points that Professor Schwartz made, that unless you're experienced with investigations, you might not have caught the point. But she says when officers get to wait 24 hours before you can talk to them. And the reason why that's important is because police agencies know that when they arrive, they get a call that there's a homicide, and they arrive at the scene. They're trying to immediately find witnesses that were under the excitement of the event, because you may not have any better opportunity to get a statement from that person. Because if that person is able to step away, calm down, and think about what happened and think about the ramifications of giving a statement, you may lose that witness. And so it's a similar belief that give the officer 24 hours to calm down, relax, think about what happened. So that's what's behind that. But I don't necessarily begrudge the unions for trying to negotiate the best contracts that they can negotiate on behalf of their clients. It's just that anytime we talk about anything in the criminal justice system, what is underlying everything that we're talking about is the fact that whether we're talking about police officer unions, whether we're talking about any aspect of criminal justice, there appears to be two systems of justice in America, and that certain groups are treated one way and other groups are treated another. So when we talk about unions, it's in the context of when an officer commits a shooting, the public says, now, if I did that, I'll be sitting in jail. And so they're seeing these two systems at work. And I think one of the bigger examples is what we saw on the Capitol on January 6th. I think that whether people want to acknowledge it or not, many African Americans were sitting there watching that saying, now, if there had been a bunch of African Americans attacking the Capitol, I think there may have been more than just one person shot. And my point is that there appears to be two systems of justice at work.
Understood. Along those lines, there's a question from the audience. I got more questions I could think of that the time allows. A great question we got from the audience is about body cameras. Body cameras were supposed to be, or sort of presented as a panacea to the issue of police misconduct. We can videotape these body cameras. We can show you in real time what the officer did from his or her point of view, and you be the judge, literally, as a juror or grand juror or a public at large. The implementation has been a little uneven, to be generous. Now, when people, and there have been so many instances where the public learn that the body camera was turned off, inoperative, right at the moment of the disputed issue, the shooting, the beating, what have you. What, in your experience, I'll start with you, Professor Schwartz, and then Ms. Baker, what has been sort of the remedy for that? If there is a remedy for that, is it prosecution? Is it lawsuits? Is it administrative discipline? What seems to be the way that police officers and police departments are being held accountable for the selective use of body cameras?
I'm not aware that there has been too much in the way of consequences. And I think that when there can be disciplinary proceedings, if an officer, is not following policy. I don't have a, study examining how often that happens, but my sense is that, it happens many times when there are no consequences. There's a whole separate, when you're thinking about civil rights litigation, to sue the city for their own constitutional violations, to argue that the city has or county has itself violated the Constitution, you have to show a policy, custom, or practice by the city that causes the violation. And that standard is as hard in its own way as qualified immunity, because you often have to find prior cases where the same thing happened and it was found to have violated policy, and then that caused the incident. So if you're thinking about cameras, you would have to find prior cases where officers didn't turn on their cameras, were found to have violated policy not turning on their cameras, and then that the failure to turn on the camera somehow caused the violation. And it's a hard standard to meet. And so, you know, I do think that individual officers can sometimes be disciplined, but I've been reading about a bunch of cases, you know, in my research, and I don't see a whole lot of discipline for turning off cameras.
Ms. Baker, what are you seeing in your practice when it comes to the sort of the Venn diagram overlap of police misconduct and cameras being turned off?
Well, I mean, we know that's a huge issue. And, you know, my later years of being a prosecutor were right when body cameras were becoming a thing, and the Louisville Metro Police Department outfitted all of its officers with body camera. As a prosecutor, I absolutely loved it because it's either I have the proof or I don't. Well, at first, officers loved it too because it helps with convictions and it helps with getting pleas. But then when it started to show maybe things that they were not doing right, then you start to see it be turned off more or things like that. Now, I'm not the person that says we got to criminalize all of this. If they turn it off, we got to criminalize it. I do think there needs to be a disciplinary procedures in place, significant so that it's truly a deterrent, not to turn off your body camera, or truly, you know, that you're truly incentivized. Like, I need to make sure it's on. You know, you really have to turn it on. So sometimes they're turning it off when they're getting ready to do whatever. Some it's just never turned on. So you have to really make the disciplinary, whatever penalty it's going to be, it needs to be significant so that it's truly a deterrent or an incentive to turn it on. The other thing I think that needs to happen is when there is a dispute, there needs to be, if an officer turned his camera off or never turned it on, I think the presumption needs to go to whatever, you know, Johnny says happened. Like, you don't get, like, the body camera is supposed to be there to protect police and civilians. If the officer's the only one that's able to control whether or not it's on, if it's not on, then the presumption goes against what you're trying to say happened, in my opinion. It can be a rebuttable presumption, but there has to be something really tied to not having the body cameras on for them to have the impact that we want them to have. And I do truly think that if they are utilized the way that they're supposed to be utilized, that they would have the impact. The other thing that we have to take note of, though, is what we see happen here a lot is our local police officers have them, but if they're on a joint task force with federal agents, they don't have to wear them. And I don't know so we need to really push for body camera legislation at the federal level too. So states have implemented, local police departments have implemented them, but the federal government still doesn't like body cameras, but they should have them. Like, I don't get there's no rationale of why the feds do not have them, in my opinion.
One question from the audience was about sort of police accountability. And he talked about how, in his experience, he worked with the administrative separation for police officers. So sometimes there are instances where the police may be accused of criminal misconduct, they're acquitted, or the case does not go to trial, but they're still held administratively liable and fired for cause, right? Due process, termination of their government employment. Does anyone think, I'll start with you, Mr. Wiley, do you think if the public knew more about the fact that sometimes police don't face civil liability or criminal liability, they just get fired for cause, would that help give people more confidence in the system and that there is some degree of accountability?
Yeah, I do think so. Because I think a lot of times the cases that get the most attention are the cases that result in someone's death. And, those are the cases that get all the media attention, but there are a whole slew of cases in between where there may be some accusation of police misconduct, and it results in administrative action by the police agency that never really gets advertised. And where had it been advertised, the public would have probably been very satisfied with the ultimate outcome, or would have gotten at least a sense that there was some accountability in that particular case. So I would say that I think that police agencies need to do a better job of advertising that there was accountability, understanding its importance to the community, and it also looks like the police is doing a better job of policing itself, because that's another big complaint that you'll find in many cities around the country, is that people don't really have a lot of faith in police agencies policing themselves.
But I think to add on, the next step that has to happen there is a registry, so that they don't just get fired from one agency and go work in the neighboring agency. So unless we're doing something to prevent them from being hired by other law enforcement agencies, I really don't care that they got terminated by agency A if they're going to be in the next county.
And to your point, Ms. Baker, a lot of times they resign before they're fired, so that they can affirmatively say, "I've never been fired." I want to ask on that point, Professor Schwartz, do you see in your research a correlation in jurisdictions where maybe if there is more accountability, more cops get fired for misconduct, the civil liability, the judgments paid out, or less, or does it really not matter?
I think it's really a complicated story to look at. And I would just say before I just to pop in on the prior question, I think that it's an open empirical question, sort of how often officers are disciplined, and how that relates to settlements and criminal prosecutions. I just put in the chat, there was a story, and I was looking for another, I couldn't find it, but that there's often large payouts in civil cases with no discipline at all to those officers. So, it's an open question how often that happens. I think that there is, I've looked at regional variation in these cases, and there is very significant variation in part of my study that I looked at was Philadelphia and Houston. I found that in Philadelphia, over the same period as in Houston, there were 10 times more lawsuits filed against Philadelphia police officers and 100 times more awarded to plaintiffs in those cases. And you could look at that and think, wow, what's going on in Philadelphia? Those Philadelphia officers must be 10 times worse or 100 times worse than Houston officers. But if you look at the data, Houston officers have killed more people per capita than Philadelphia officers. And more have been removed from the force. So it's really hard to know how good or bad a police force is, or how often people engage in misconduct. I actually think that the differences between the two have more to do with what I call the civil rights ecosystems in those parts of the country. In Texas, the judges are more likely to dismiss cases on qualified immunity and lots of other grounds than in Philadelphia. The state law is harder to use in Texas than in Pennsylvania. The juries are more hostile in Texas than in Pennsylvania. And all of that means there's fewer lawyers like Ms. Baker who are willing to bring cases in Texas than in Philadelphia. I found when I looked, there were 3 lawyers who had brought more than 2 cases over a 2-year period against the Houston Police Department. And many lawyers, as Ms. Baker was saying, will file 1 or 2 cases, spend $20,000 of their own time and money bringing the case, have it dismissed on qualified immunity, and think, you know what, I'm going to go bring personal injury cases instead, or medical malpractice cases that I understand, where I don't have to deal with qualified immunity. In a place like Philadelphia, there have been lawyers bringing civil rights cases for decades, and they have really built a plaintiff's bar. So I think that there's more cases in Philadelphia than in Houston, not because there's more misconduct in Philadelphia than in Houston, but because there are all sorts of aspects of the environment there that make it easier, still not easy, but easier to bring these cases.
We're running out of time, but I want to ask this question. There was a lot of legislation proposed in Congress this past summer because of the Black Lives Matter protests, and sort of the kind of we reached critical mass as a country, realizing that of the racial disparity and police brutality and police violence. A lot of it was stymied in the Senate. However, we have a new president. a new Congress and eventually a new Attorney General. What are your expectations? And I kind of open this to anyone here. What would you like to see this new administration and new Congress do to address this issue of police violence, accountability, and again, as you said, Mr. Wiley, the two systems of justice that are both perceived and also in practice in this country?
Well, if you guys don't mind me going first, I think in California, there is a clear movement to moving the pendulum to the left in terms of in many aspects of our criminal justice system. In fact, we now have a new law that's coming into effect, I believe January 2022. It passed this year, and they said, but we're going to give the courts and the system a year to prepare. And so they are changing the jury selection process. And the whole idea is to get more minorities serving on the jury. And so the process, if you are a prosecutor and you excuse an African-American juror or Hispanic juror, anyone who's a member of a cognizant class, the presumption, no matter what the juror said, that is the basis for you bumping the person off the jury. The presumption is that you have committed some kind of Bastin Wheeler error, and you have to explain why you are excusing that juror. And the whole process is to make the jury process a more fair process. That's one example. But I think in terms of police officers in the criminal justice system, where I think some of the biggest changes need to occur, I do think that all police agencies, and it should be federal legislation requiring that the 18,000 plus police agencies in the United States all have some policy or some form of policy of requiring de-escalation training by everyone who is allowed to engage in deadly force must go through de-escalation training. I think that is imperative. Because there's just too many situations that we see officers arrive at the scene, and not many times, but there are times where it is the officer who is escalating the situation that sometimes results in the use of deadly force and someone dying. And so that's a major, I think, something that I would like to see. And then I think what Juanita mentioned, where an officer receives some form of discipline, and then they move on to the next department, and then you see similar violations and where the officers committing the same act, but just at the same acts, but at a different agency. I think that needs to be dealt with. And then finally, I would say that to have a national registry or a national use of force training policy, so that we get more continuity and more uniformity regarding the use of force. Because right now, different states, different cities, they all have different use of force policies.
Professor Schwartz, new Congress, new president. What are you hoping in terms of reforms in the next couple of years?
I think all of the suggestions that Mr. Wiley's offered, I endorse too. There are so many different things to do. I think that there needs to be to just take the last point about uniformity and use of force training. There's almost 18,000 law enforcement agencies across the country, and the vast majority of them are small, and they are really given the power to police themselves, to decide what their policies are, to decide what their trainings are, to decide how they collect information. there's a lot to be done. There was a bill that Senator Warren had introduced last year to create a kind of accreditation, to create sort of more muscular accreditation like you have of hospitals, like you have of other, of other kinds of industries, so that there's evidence-based policies and data collection and all of those things. I think that would be extremely important. The other thing that I would just say is on the back end accountability point, and the civil justice side, we do need to make it easier to achieve the goals of compensation and deterrence. And that's involved with making it easier to sue. There's a bill that was just passed in Colorado that I think does a lot of what I think that back end accountability in the civil system should look like. And I encourage you to take a look at it if you're interested.
And I co-sign everything that everyone's already said, but I have to be that person that says, we can talk about de-escalation training, but we know that the officers know how to de-escalate because we see it when they're not dealing with Black people who they perceive as a threat. So it's not that they necessarily need more training, it's that we need them to apply the training that they get to everyone equally. Right now, there are some departments who do need more training. So I'm all for training, but sometimes we give the pass when we say, oh, they need more training. Oh, they need this. They know exactly what they're doing. They know that it's wrong, and they need to be held accountable for those actions. And that's both criminally and civilly. I think that, I look here in Breonna's case, and there's no reason that the officers involved with her killing should not have been indicted. In fact, grand jurors have come out and said, we wanted to indict them, but a prosecutor took it upon himself to say, nope, we're not even giving you that opportunity, grand jury. That's not applying the law equally. It was not that prosecutor's job and role to do that. So it's just, we have to truly, and until we begin to hold officers accountable, both criminally and civilly, like, yes, we can say civilly, but until their freedom is on the line, do we really get much change? So I'm hoping, our case is still being investigated by the federal government. I'm hoping some federal civil rights violations come down, criminal civil rights violations, but we have to hold them accountable, hold officers when they behave badly accountable. Again, I'm a former prosecutor. I have many officers who are friends. I want them to be able to do their job without the scrutiny that they're under, because other officers choose not to do their job within the boundaries of the law.
I think that's a perfect way to end tonight's or this afternoon in California, this discussion about civil rights violations, sort of what we as citizens can do, but we should know more about. And if you don't like the way things are, then use your voice, speak out, talk to your elected representatives, make your voice heard. You see the power of that this summer, and you really see the power of that in elections. Before we end, I do want to just remind everybody, you see in the chat, but we're going to have another one of these more targeted youth audience this Sunday from 1:30 to 3 p.m. Eastern time. It's your time to talk. What's going on educating our youth on the law and lawyers in the movement. It's going to be a fantastic discussion. Youth are going to be involved. We're going to be talking to college students and people who are there, not some old guy like me. It's fantastic. But I want to thank everyone. Again, thank Ms. Lanita Baker, Professor Joanna Schwartz, Mr. Terry Wiley. Thank you so much for your contribution and enlightenment. Again, thanks again to NBA President C.K. Hoffler, Jamie Boston, the chair of the Veterans Affairs and Military Law section, Augustus Turner for his wonderful sort of like overview of the process, the men and women of the Veterans Affairs and Military Law section of the National Bar Association. Special thanks again to the tech team from the First Baptist Church of Annapolis, Maryland. All the things you see from this webinar to the slides to the cool videos you see, this is all done through their efforts. In particular, Quay Crowner, Russell Pickney, and Jasmine Crowner. We see you guys. Really appreciate all you've done. I've just sent in the chat the email address for our section. If you like what you see, if you want to know more about the National Bar Association, go to nationalbar.org. If you are interested in the Veterans Affairs and military law, don't have to be military, don't have to be a veteran. You just care about those issues, and you see what defines veterans issues is very broad. We're not just talking about VA, right? If you're interested in that, that's the email address. If you have questions you want answered, maybe we can get to these panelists later on and try to reach out to them. That's email. But again, panelists, thank you so much. I think we've all deeply appreciated, benefit from your wisdom tonight. Everyone in attendance in Zoomtopia, thank you so much for coming out. And until we meet again, you have a wonderful, wonderful day. Stay safe.
Thank you.
All right. Thank you, everybody. Good seeing everybody.
You guys should be able to hang here. I think we're going to pull us out. We'll see.